To the Newlands Sports Science Institute here in Cape Town, where we are talking mainly doping in sports as part of a conference which is termed I Play Fair sports law conference that is currently underway here. It started yesterday and it's meant to conclude today, where various stakeholders from the sports fraternity have gathered here today to discuss various challenges, starting from doping to match fixing to the ethical issues and questions surrounding sport and participation in the world, and not only in South Africa. It is also a precursor to a global conference dealing with the same issues, which will kick off in Johannesburg from tomorrow onwards. But joining me now is Professor John Wolohan, who's a professor of sports law from the United States. Now, sir, you put together today a presentation dealing specifically with the Lance Armstrong case, which has become a worldwide known fact. Can you just very briefly take us through your presentation today?
Okay, sure. Basically, what I'm going to do today is kind of do a critical analysis of USADA, which is the U.S. Anti-Doping Agency's basically a critical analysis of their case. Some people complain that USADA maybe overstepped the bounds in trying to get Lance Armstrong. Did they kind of, ignore some of the basic due process rules and even some of their own internal rules in bringing their case? And so what I'm going to do is I'm going to look at, due process requirements. What about the 8-year statute of limitations? How does that come into play? And some of the other requirements that the courts looked at.
Now, judging from what you've just said now, then one would sort of assume that there must be a lot of red tape and a lot of processes and procedures that need to be followed in order for you to get to the root of the problem, or to identify one as one who's been cheating. Is that perhaps not part of the problem, that there's so much that needs to be done, that so many people are getting away with it?
Right. Well, I mean, I think to some extent that was true in the past. I mean, USADA and WADA, they've created an organization that hopefully tries to cut through some of the red tape. And what USADA was able to do with the Lance Armstrong case is they were able to act independently, even though UCI, which is the International Cycling Association, and USA Cycling decided that they didn't want to bring charges against Armstrong. And so USADA was able to act independently and bring those charges and bring Lance Armstrong to justice. And so I guess the hope is that, these independent organizations can cut through some of the red tape and even the conflict of interest some of the other organizations might have.
Now, I would be sort of skeptical and scared to say there are people who are meant to be looking at such issues, and then when it comes to specific cases, we don't want to press charges. When it comes to others, we don't. Surely that must be problematic as well.
Well, and I think that's the gist of the argument with Armstrong. I mean, a lot of people have argued that the international governing bodies of cycling and the domestic governing bodies didn't want to bring the Lance Armstrong case because he brought a lot of money to cycling. He, brought millions of people. Fans. He was a huge the cancer advocate and anti-cancer work that he did with his foundation. So he was a global sports icon, and people were afraid to bring these cases against him, and they didn't want to bring him down. But USADA was able to kind of work independent and did the right thing.
So that would then answer the question why it took so long to bring him down, if it was known for a while that, he was suspected for a while.
Well, he was suspected, but once again, it has to be argued that there were no positive tests against him. So what they brought against Lance Armstrong was a lot of non-analytical information. So we have testimony by Floyd Landis, we have testimony by Tyler Hamilton and some of the others in the cycling community that said, they saw him dope. They saw him take performance-enhancing drugs. They saw him blood dope. But they don't have an actual positive test against him. And so, we're kind of looking at it a little differently now because, before we could bring a charge against you, you had to test positive. So Tyler Hamilton at the 2004 Olympics, he tested positive for EPO, and so we could bring that case against him. We don't have those same positive drug tests against Armstrong, so it makes it a little harder.
So we're most likely then to see perhaps taking a different approach in terms of trying to get to the root or trying to get evidence against someone despite the positive testing.
Right, and then I think once again, even without the positive test, USADA was able to use those testimonies that they were generated through a different the U.S. Justice Department had actually tried to investigate Armstrong, and they were trying to build a case against him. And right before USADA filed their arbitration case against Armstrong, the Justice Department actually dropped its case. So they had a lot of testimony, they had a lot of evidence already built. So the USADA was able to kind of piggyback on that and take that. But once again, it's kind of raising a kind of a very gray area here. If all of a sudden we're going to start prosecuting and penalizing people for these non-analytical tests, it does draw some concern. I mean, we've got to be really careful that all of a sudden, even though you haven't tested positive, we're going to punish you because of other things.
No, indeed. Thank you very much. Professor John Wolohan is a professor of sports law from the United States, telling us basically just some of the challenges that are indeed still faced in trying to come to terms and trying to bring people to book, talking to us about red tape that is there that sometimes prevents or slows down the process of bringing people to book who do engage in such activities in sports. But that's all we have from the Newlands Sports Science Institute here in Cape Town. We'll now take you back to Marumo in Jordan.